How are you guys doing, Sandy and Madeline?
Wonderful.
I'm doing great.
Excellent, excellent. I'm so excited to have you. You're one of our first special guests, and you work at the law office of Charles B. Musselwhite, a good friend of Sandy, correct?
Yes.
Yes.
Without a doubt. Charlie and I have been working together for more than 10 years now.
Oh, wow. How did you meet Charles?
We met in the course of the West disaster,
Oh.
where we were both part of a consortium of 4 different law firms that represented about 170, 180 victims of the explosion. And that got us working together. We've done other cases since then, but that was almost like a career case. That
Yeah.
case lasted more than 10 years
Oh, wow.
through a number of iterations, and it was an enormously complex case. It was
I bet.
fascinating. There were 30-something different experts in a wide variety of fields that were deposed over the course of the case.
I bet. Did you learn a lot in that case?
Yeah.
Was that earlier on in your career?
That was that case started about 11 years ago.
Yeah,
is when
okay.
it started, yeah. So it was interesting. Yeah,
I
because
imagine.
the explosion was in April of 2013. So we just had the 10th anniversary, and now we're up to 11 years. And there's actually a little tiny bit of the case that's wrapping up right now.
Oh.
And hopefully the last of the paperwork should be done within the next couple of months.
Excellent, yeah.
But that's how we got started. And then all the time we spent interviewing clients and preparing that case and investigating facts and working with the other major plaintiff groups. There were 2 other major plaintiff groups in the course of that case. So along with the other 2 firms who were working with us.
Oh, excellent.
That's a long story about how I
There's a
got
lot
to
of
know
history there, I
Charlie.
can
Yes.
see. No, that's great. And Madeline, how did you get involved in the law firm?
For sure. So I have been working there. It'll be a year next week.
Oh,
coming up
congratulations.
End of May. Thank you. And I found out about the firm. So Charlie, for background, I used to work at Starbucks as a barista during college. And the Starbucks, the area that I was in, that's where Charlie lives, and he was a regular there. I didn't really interact with him much. But one of my coworkers had started working for him, and she got a different job opportunity and decided to go there, but knew I was unemployed at the time. So she had asked if I was still looking for work. She spoke very highly of them, and I was considering going into the legal field. And so I wanted to see, okay, like what's going on? Like, what is this like? And
Right.
it seemed like it would be a pretty positive work environment. So I was
Right.
like, okay. So interviewed, and I've been there now for and I like it. So
That's awesome. And what were you studying before?
so my undergrad degree is a BS in political science, and then
Yay.
my minor was in law, value, and policy.
Okay, smart. Period. Love it.
What is law, value, and policy?
Law, value, and policy is a major in which, or not a major, a minor in which I took more sociology classes than anything else. You had the option to do or study different classes that kind of focused on, like, you know, how the government functions or stuff like that. But I was really interested in the interaction between how the government functions and people and like that sort of relationship. So I was able to focus primarily on that with my minor.
Oh,
Get some
excellent.
cool electives.
Yeah, and you mentioned you were unemployed for a period of time.
Yes.
And I think there's more to the story.
Yeah.
So why were you unemployed at that time?
So I, about a month before I started working at that law firm, I was fired by my employer, Starbucks, due to my involvement in organizing a union at my store
Yeah.
that I had been at for a couple years. At
So
that
you
point.
led that union.
I was one of our lead organizers, yes.
Yes, and I have so many questions. First of all, I have so much respect for you for doing that work and unionizing and making sure that you and your coworkers felt represented. So that's really amazing. But I wanted to understand, like, what really motivated you to unionize in the first place?
No, for sure. I think for a lot of different people at our store, I mean, there's a general consensus of like, we know that we can be afforded these things that are supposed to be provided but aren't provided, yada da da. But for me personally, I fortunately was in a position where I was still on my parents' insurance. I was in a much better spot than a lot of my other coworkers who rely on that job for insurance and all the benefits that come with it.
Right.
And for me, I at that point wasn't sure. I was about to graduate, or I guess by the time that we had started unionizing, I'd already walked the stage, and I was kind of at like a standstill of like what I wanted to do. I wasn't too sure, but I just knew at that point, like, I like my job, I like my schedule, I like what I do.
Right.
And whenever talks started occurring throughout our store of unionizing, and hey, have you heard like what's going on in Buffalo? Like,
Yeah.
like what do you think is going on? To me, that was appealing just based off my studies of the interactions like with like government, how different
There was an
systems-
urge for you to do something. Yeah, for
I
sure.
think I've always wanted, I know it's corny, but I've always wanted to like help people, for lack of a better word. And I
Absolutely.
think one area in which people are not, it's not taken as seriously as like labor in America, and
Right.
everyone has to work.
Yes.
And at Starbucks, whenever you're hired on for stores, like you don't have a formal contract with them.
Right.
It's at will. You can get fired anytime. They can change it, you know, one day, and you just have to be
And
aware.
you're screwed,
and,
yeah.
yeah. And to me, that's not cool. So
Fair.
I was like, well, if we are able to organize ourselves and create like a power structure in which we're able to achieve a contract, that is very appealing to me, because that's something that will not only impact people within my store, but just across the company as a whole, and potentially other work sectors,
Yes.
if they see it's possible. So that was appealing.
Yeah. And I mean, it worked. I'm boycotting Starbucks, and all my friends in college, we are having like stands. I go to the university at Texas at Dallas, and so we have stands where we end up getting coffee instead, like clubs and stuff
Yeah,
organize
yeah.
it. So, part of the people.
Yeah.
And Sandy, I was wondering, do you have any background in unionizing?
No, I've stayed away from that. It's in particularly in Texas, where if you're on the East Coast, if you're on the West Coast, there was a much greater percentage of the workforce is unionized.
Yeah.
Texas historically, as one of the so-called right-to-work states, did not have as significant a union presence.
What does it mean, right to work?
Right to work means that the union cannot bargain to have what's called a closed shop. In other words, you cannot impose a requirement that every worker has to be a member of the union.
Okay.
And so you have so-called right to work laws, which is you can work at an employer without being a member of the union. Which tails off into all sorts of interesting things sort of beyond the scope of today, which are the so-called free rider issue of if everybody else in my workplace is a member of the union, everybody else is contributing to a strike fund or to organizing activities, and eventually they, through their effort, create a contract, then I know that the employer is not really going to treat me differently from the way they treat them under the contract. So without getting my hands dirty with any of the union, I can reap the benefit of what they have done. And
Right.
that was sort of one of the issues of labor law. And clearly, if you've got a union, you've got organized. You don't want a whole group of people who can come in and sort of free ride on that. But
Right.
I'm not an expert in that area. It's a whole different area. People think of lawyers as like an employment lawyer can do that. Well, you have employment lawyers and you got labor law lawyers, and labor
I didn't
law
know that.
lawyers. Yeah, employment lawyers, they overlap by quite a bit, but the lawyers whose practice is before the National Labor Relations Board under the National Labor Relations Act, that is a specialty really unto itself, and very separate from sort of run-of-the-mill doing discrimination, at-will employment cases, things like that, or wrongful termination cases in those states that have wrongful termination laws. So it's a species of employment law that is different, and
Right.
historically predated it, because the the primary act under which people organize unions in the U.S. is the National Labor Relations Act, which was born out of the Depression in the 1930s.
Oh, wow, yeah.
Yeah, there had been a whole slew of strikes across the nation. There were citywide general strikes. There were factory takeovers. There was no good federal statutory support for the organization of unions. And so everybody did all sorts of things. You had violent confrontations between the workers trying to form unions and the police and the private security forces who were defending the interests of anti-union employers. And in 1935, I need to remember to say that since it's almost 2035, the National Labor Relations Act got passed and got signed by President Roosevelt, and it largely governs how unions get organized. And it has many of the acts of Congress, and the NLRA, the National Labor Relations Act, was part of that. Share an intro part, which is where Congress goes in and essentially makes findings. That it's a preamble that says this is why we are passing this law and where we hope we are headed. And the NLRA had a long preamble that was really kind of interesting. So this is where we just get totally nerdy and read some actual positive law like passed by Congress. So
yes,
and I'm sure you'll see if this rings a bell with you. So in Section 1 of the National Labor Relations Act, Congress finds that the denial by some employers of the right of employees to organize and the refusal by some employers to accept the procedure of collective bargaining had led to strikes and other forms of industrial strife or unrest, which have the intent or the necessary effect of burdening or obstructing commerce by impairing the efficiency, safety, and operation of the instrumentalities of commerce, by occurring in the current of commerce, by materially affecting, restraining, or controlling the flow of raw materials or manufactured or processed goods from or into the channels of commerce, or the prices of such materials or goods in commerce, and causing diminution of employment and wages in such volumes as substantially to impair or disrupt the market for goods flowing from or into the channels of commerce. Let me step back for a moment. Why, might you ask, do they always say commerce, commerce, commerce?
right.
It's because in the Constitution, Congress is given the power to regulate interstate commerce. So the laws they pass, they go to quite an effort to tie that to interstate commerce.
And so can you simplify it, like English, please? Like that was a lot of information for our listeners who are maybe not well-versed in legal language.
Well, let's see what the next paragraph of the intro of the Act says. It says, the inequality of bargaining power between employees who do not possess full freedom of association or actual liberty of contract and employers who are organized in the corporate or other forms of ownership association substantially burdens and affects the flow of commerce and tends to aggravate recurrent business depressions by depressing wage rates and the purchasing power of wage earners in industry and preventing the stabilization of competitive wage rates and working conditions within and between industry. Experience has proved that protection by law of the right of employees to organize and bargain collectively safeguards commerce from injury, impairment, or interruption, and promotes the flow of commerce by removing certain recognized sources of industrial strife and unrest by encouraging practices fundamental to the friendly adjustment of industrial disputes arising out of differences as to wages, hours, or other working conditions, and by restoring equality of bargaining power between employers and employees. Experience has further demonstrated that certain practices by some labor organizations, their officers and members, have the intent or the necessary effect of burdening or obstructing commerce by preventing the free flow of goods in such commerce through strikes and other forms of industrial unrest or through concerted activities which impair the interest of the public in the free flow of such commerce. In other words, you don't want to go to get your Americano in the morning and discover that your Starbucks is closed down because of a strike.
Oh no.
So the elimination of such practices is a necessary condition to the assurance of the rights. So it was declared in the National Labor Relations Act. It is declared to be the policy of the United States to eliminate the causes of certain substantial obstructions to the free flow of commerce and to mitigate and eliminate these obstructions when they have occurred by encouraging the practice and procedure of collective bargaining and by protecting the exercise of workers of full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or other mutual aid or protection. And those are the findings of Congress that were the genesis of the National Labor Relations Act, long before you were born. So tell us some of your experiences in working towards getting designated representatives.
No, for sure. So one thing which my understanding is it's a little different than how other unions kind of operate. Other unions have representatives that'll go into where you work and talk to you about the union and whatnot.
Yeah.
With Starbucks Workers United, it's all worker led. So
Wow.
like everyone that is planning all of our collective action, as that describes, different ways in which we are strategizing.
Well, I had a question. How do you gain that bargaining power? Why is there power in a collective action?
For sure. So on the topic of commerce and obstructing the flow of commerce and whatnot, for Starbucks specifically, that for us is the drinks and food and cups and all that stuff that we sell. That for them, that's where they get all their money, and they have
Right.
promotions and all sorts of stuff. So for us to increase our bargaining powers, we have to organize and strategize on how to obstruct commerce in a way that shows them that like we're
We're the foundation.
We're not actually doing anything. Like if you're, you don't want us to do this, I'm like, it's well within our rights, and also it shows that we have power as workers,
Yes.
just because, especially with how big that company is and the turnover, it's so easy for them to fire someone and then bring someone in, and not a lot of people stay there.
Does it have a high turnover rate?
I'm not too sure what it would be now. I know that the pandemic certainly affected things. That was a
Right.
big turning point for Starbucks Workers United. It essentially came out of the pandemic, and
Oh, that's interesting. Yeah.
that for them it was, being an essential worker working in the food service, and you're required to go to work and basically at that point put your life on the line. This was, before all that,
100%.
you are so essential. However, we're not going to compensate you as such. Matter of fact, we're going to actually try and, for them, they view it as cost efficient of, scheduling the most minimal amount of people they can to just get the job done and to meet the metrics they want to do, without regard to how that affects workers, how that affects customers as well. For the most part, it affects customers tremendously.
Really? In what way?
Absolutely. So, for example, if you're going through a Starbucks drive-through,
Yeah.
they have little sensors that tell you how long a car is taking an order, how long they're waiting until they get to the window, how long they're at the window. And the company tracks these metrics where, for example, during the busiest time in the morning, they want someone to be at the window for no longer than 45 seconds. So that's 45 seconds
quick.
to get your stuff and pay and get out.
Right.
And if you are not meeting that quota, they have some sort of system and how they decide how they're going to schedule, where if you're not meeting that, okay, we're not going to give you as many people on the floor, which you would think that's counterproductive.
Right,
The more
yeah.
people you have, well, to them, like, well, we're not making enough money because people are at the window too long. So, you need to fix that. And
so they like kind of punish you for it?
they do. And there's no, let's say a machine's broken one day. That's not
Right.
taken into account. They're not going to make a little note of, oh, machine was down, or, oh, like 2 people were out sick. That's not taken into account. They just look at the numbers and they compare you by district. And let's say you're doing good, you may get a high five. Like if you're lucky, you're going to get a high five. Like,
That's terrible.
maybe some pizza. If,
Not the pizza parties.
if the manager's feeling crazy. But in general, like, for us to gain bargaining power, we go on strikes, which we have done. Specifically, we've had 2 what we call Red Cup rebellions.
Oh, interesting.
And so Red Cup Day is the most profitable day for Starbucks. It's whenever they launch their Christmas drinks. And during that launch, they give out these Red Cups. And it is, it's ridiculous. I say ridiculous. I understand it's it's fun. It's the holiday season. You want your little mocha or whatever. And people.
I've never actually been in a Starbucks on Red Cup
Oh.
Day. I've never
Oh,
seen
that's-
them handing it out.
Yeah, no,
So,
it's
because it's the Christmas season, when do they do that? Like August?
November 17th.
Around then?
I-
the
around
pumpkin
there?
spice latte or something?
No, those come out in August.
Oh,
Those
okay.
come
This
out.
is,
That's
this is
it.
going to be
Yeah.
all the Christmas stuff with the cup, like all
Oh, that's so interesting.
that holiday stuff comes out. It's a big deal. They advertise it, like they change the the colors of the app, so it really gets your attention. Like,
yeah,
this is
yeah.
going on. Super, super profitable. So for the union, that was a very obvious point of
To target that.
yeah, no, exactly. Like if we can show them like how this affects their business, like we are essential. We do have power, and
Yeah.
if you're not gonna bargain with us, okay, then we will go on strike because we are asking you to bargain with us, and you are supposed to do that.
Right.
But that was not the case for the first, like, I guess 3 years of the movement. So.
And what challenges did you face? I imagine there's many when you're causing that much friction.
Yeah, so part of because I have like an ongoing case, it's actually set for hearing in June, with regard to my termination and also failure to promote. Prior to my store going public, which is part of the process, is you have to announce to the public and your superiors, managers, company bosses, hey, we have the intent to unionize. We want to hold an election. That's like part of the process.
Yeah.
And prior to that, we had a change in management. And before that change, I was in the process of getting promoted to essentially like key holder.
Okay.
And for me, I had been a key holder at previous jobs. I needed to make more money. I had been working there for quite a while at that point. I was very familiar with the processes and the standards that they hold you to. There's a lot of training that goes into working at Starbucks, surprisingly.
What's a key holder?
A key holder, that's going to be like someone who like they're not going to be the manager of the store, but they have the literal keys to like open and close the
Okay.
store and handle cash that's moving from one register to another and
Right.
Yeah.
stuff like that.
And what is the wage that you were offered for that?
So I think at that time for key holders, it was, at least in Texas, I think $20 an hour, $21 an hour. I want to say, I can't remember at that point in time, it may have been lower for unionized stores
Yeah.
because part of what Starbucks was doing was whenever they would roll out benefits or raises,
Yeah.
they would not implement them at unionized stores because their thought process was, well, we can't make any changes, like, however, that was like the only situation in which they like didn't want to implement something. We waived, like, if anything was going to be better, we had no problem with them implementing that. We didn't want to bargain over it. Like, that's okay.
Yeah.
However, the company, that was a way for them to kind of scare off people from who might be interested in it, because it not only makes it look like you're doing something wrong, but it also is literally financially hurting the pockets of the workers,
Right.
and that's in a way helping fill the pockets of the company if you're not paying certain people as much as other people because they are trying to get a contract, you know.
Yeah, and when you say you're talking to Starbucks, like who's that spokesperson for them? How are you communicating with the company?
Yeah, so on a store-by-store basis, for me, if I'm sending out like a strike notice, which I had to do in order to protect everyone and make sure they knew what type of strike it was so that we wouldn't get fired for not going on strike, that would go to like my store manager and my district manager via email.
Okay.
And like I would just email it right before we would start. I tried to give them as, you know, little notice as possible.
Right. Yeah.
And
what,
then,
what do you put into a strike notice?
so I should have saved a copy. I probably have an email that I can pull up for reference. But essentially you say like, this is notice that the members of this store at this location are going on strike starting at this time on this day and ending at this time on this day. And this is an unfair labor practice strike. Specifically, we intend to return to work type of thing. And I can't remember if you state, I'm pretty sure you state like why you are, but all you really have to say is we're going on an unfair labor practice strike. And then you email that to them, and I would specifically list people who I knew would be participating in the strike, just for more coverage of people. I was terrified of like being the reason someone loses their job.
Right.
So I wanted to make sure, you know, everyone's covered. And that was how we would communicate on that level. And then through our union, we have Starbucks Workers United is a part of Workers United, which is a part of SEIU.
Yeah.
And for Workers United, we have Lynn Fox, and she is the lady who communicates for our union with Starbucks. So whenever we're asking them to bargain, we're like requesting these things, if it's with like the higher ups in the community, it's going to be through her specifically.
That's, yeah, because I was going to ask you what type of like networks or coalition work did you know, I'm assuming there had to be other resources that helped you gain that momentum.
Oh, for sure. So thankfully at the point in time that my store had expressed interest in unionizing, the union itself had a pretty good structure going on. We are kind of organized by, I mean, we have like our like Houston area, but then there's also, it's organized by region. And
Yeah.
so there's a Wild West, I'm pretty sure there's probably a more formal term for it, but that's like the name we have for our like group chat. It's going to contain like Texas, Louisiana, Arkansas,
Oh,
a
wow.
bunch of different states.
Yeah.
And so we're able to kind of organize on like a state level too, because it's going to vary depending upon, you know, what like Texas, like Sandy said, is a right to work state. That's going to be different than, you know,
Another state that may have different laws.
no, exactly. So it also helps, you know, you organize on a micro level, and then you organize, you know, there's, you know, layers to it. But we had like that structure in place. And then also there was a ton of support from other unions within the Houston area.
Oh, that's amazing.
So, like the electrical workers union, we
wow.
had, I mean, teachers, as well as different groups like the DSA, Democratic Socialists of America,
Yeah.
Houston chapter, huge, like so helpful.
Yeah.
They would come
and it
out-
really fuels you, you know what I mean?
Absolutely, because they are reaffirming you like, oh, this is
Yes.
awesome, like you're doing, like this is going to be so worth it, you know, like once you get a contract, and we're fully here to support you, which
Yeah.
is the like polar opposite of what's happening when you go into work as
Right.
someone who's trying to organize the workplace.
Yes.
So it keeps you going. You know, you get, you know, kind of beat down, and they're like, nope, come on, get up, like
Yes.
let's keep going.
Yeah.
So they were super helpful and encouraging, I mean, on so many different levels. I mean, they're showing up to strikes, and we would do sip-ins, which is just people come in and we would have them doodle and post like pro-union, go union stuff, just to kind of show maybe some workers who just got hired on and are kind of confused as to what's going on, because management is not telling them that this store has unionized or is going to unionize.
Right.
Did
They're
you call
trying
it a sip-in?
a sip-in, yeah.
Like SIP?
SIP-IN.
Oh, okay.
I love it. That's so
Yeah.
creative.
And people come decorate and they order drinks. You know, at Starbucks, they're supposed to ask you your name. And so people who are part of the sip-in, they're going to be like, union yes, union strong, like, you know, stuff like that. And, you know, just little things like that.
Yeah. And what are the specific demands that you guys are asking for?
So we have quite a few. Right now, the tides have turned with Starbucks as of like March of this year.
Okay.
They are now coming to the bargaining table. We actually had one bargaining session let me get my timeline. It's last end of April, and then we have another one end of this month.
Yeah.
And I can't talk too much about what like is accepted as of this point, but just in general, we want, you know, if wages
An increase in wages.
an increase in wages, we want it to be proportionate to living cost in the area.
Yes.
We understand that you can't. It's going to cost different depending on where you or cost a
And
different
that's
amount depending on
smart.
where you
That
live.
is smart, yeah.
I mean, it may
And
more
reasonable.
complicate things more. However, that's, you know, just makes sense. Non-discrimination. We want there to be specific clauses about you can't discriminate based upon, you know, religion, gender, sex, sexuality, whether or not you've been incarcerated, or, you know,
Right.
parole, anything like that. No, we want the company to provide like aprons and shoes. Like people are coming in and they're working and they're required to wear non-slip shoes. You're required to wear apron.
That's
You're
a cost that you have to
exactly,
take on
and
yourself.
it's not like you're getting compensated more that paycheck because you're having to
buy new shoes.
buy new shoes. And working in food service, like you're dealing with super dirty floors, you're mopping you're taking out trash. Like stuff wears out quick, and you're on your feet all the time.
And that's dangerous. I mean, Sandy would know.
Yeah.
Yeah. No, yeah.
Particularly if you know about it and people slip and fall.
Yeah.
So
exactly.
on the required uniform clothing,
Mm-hmm.
before any of the bargaining,
Mm-hmm.
do employees change into that when they get to work, or do they arrive at work in the aprons and the shoes and
You are, I believe, supposed to leave your apron hanging in the back. People do take theirs home. You are required to wash them.
Yourself?
Yourself and launder them, which that's another thing we're asking for is because what they do, Starbucks has, they contract out a service where they return towels that we use for cleaning
Okay.
and stuff to limit like paper waste.
Okay.
And so part of our request is, okay, if they're doing that, why not launder the aprons and have them provide
Yeah.
fresh, clean aprons? Because whenever you leave it up to individuals to clean their own aprons and someone's worked 7 days in a row,
Yeah.
the last thing they want to do is like, they're going to forget to take it home.
Yeah.
And I mean, at that point, it's just,
Yeah. And so you have to buy the apron, or they provide the apron?
they provide the apron.
Okay. But you have the responsibility to
Yeah.
clean them.
And you cannot work without an apron unless you're taking trash out, because that's like health code. But
Yeah.
like you can't like forget your apron one shift. Like a lot of
Right.
people will like borrow someone else's apron and just be like, hey, sorry, I forgot my apron. Like,
Right. And so what about labor hours? Is there any request on as many hours that you can do? Are they giving you proper overtime? What about that?
gotcha. So I know that Starbucks, they do not have such thing as full-time, part-time. There's no,
Okay.
okay, you're full-time, you're going to get 40 hours, or you're part-time, we're going to make sure you get 20. It depends. And so one of the things we're asking for is we want designated, like full-time. Like we want that to be an option for people so people can have reliable income. whenever
That's so
you-
interesting.
Yeah.
And so what are the consequences of not having part-time and full-time available?
For sure. I would say like on a general level, whenever you don't have a specific idea of how much income you're going to have,
Leaves you in a limbo.
it leaves you in a limbo. You don't know, like, is something going to come up that I know I'm not going to be able to pay for? Like, you can have, you know, some good paychecks and then some bad paychecks, and super inconsistent, especially if, you know, people, you don't know what's going to happen. You don't know.
Yeah.
And with how Starbucks does with their insurance, you have to work 20 hours to qualify to become insured.
Okay.
And whenever you're working 20 hours, you know, X amount of months in a row or weeks in a row, and then suddenly you have to scale back for some reason after a certain point, like you're going to lose your insurance. So,
Yeah, no, that is very uneasy.
Yeah.
So, and sorry, Sandy.
No, I'm sorry. Are you looking at anything like predictive scheduling on the? It's like scheduling where you have a predictable schedule, so it's not just completely different.
I believe so.
From week to week, and not so many. Yeah, you get to close tonight and open at the crack of dawn tomorrow. And
Yeah.
by the way, tomorrow will be a double shift. So
Yeah.
We actually have a very specific term for when you close and then you open. It's called clopening.
Clopening.
Opening.
Yes. that is an issue. That is definitely one of the issues
Wow.
we're raising. Just because I mean, Starbucks is a coffee shop. There's my store hours initially when I started working, which they changed after we unionized. They shortened the hours, and you know, because then that's less you have to pay people, and you know, we open at like certain stores will open at like 4:30, 5 o'clock, and then they're closing at 9 or 10. My store was not as bad. We opened at 5 and closed at 7. However, if you're getting off at 7 and you did all your closing duties, you have time to go home, especially if you're a student, or let's say you have a second job, and then you have to be right back there in the morning.
Wow.
And I know it's a lot of people are like, well, it's your job, you know, and it's like that's fair, but it's like also whenever you're not afforded, you know, the resources, or they're not scheduling enough people, and
there's a line of exploitation.
And it's hard to say no when you need money, you know.
Right.
You can't afford to not take the shift if they're only scheduling you, you know, that week 3 days, and you need to get your insurance. And
absolutely, that's definitely a concern. And something that I think is a small rant of mine is like tipping. Like, I want the workers of wherever I get my coffee from to be paid for, right?
Yeah.
But when I constantly am asked to tip, I think it's infuriating, because it's like, how am I still like this company that is so rich can afford to pay this person? It doesn't have to come from the burden of my pocket when I'm already paying for a certain service. Not to mention it's like $7 for a coffee.
Exactly. That was whenever our union first was, you know, going, one of the proposals we had that we were kind of, you know, advertising, like, we're going to ask for credit card tipping, you know, because that's you know, a way to get more money for workers, especially like if they're not paying you enough. And so what the company did, where they're like, oh, that's sick. Okay, so if you've unionized, if you unionize by this date, you're not going to get credit card tipping, but all the other non-unionized stores, y'all are going to get credit card tipping.
So they do this like subliminal punishing.
Oh, it was not subliminal. But yeah, no, they would have little printouts that get posted in the back, and so we would check. There'd be 3 different columns. It's like, oh wait, we unionized or went public on this date, so I need to see, am I getting a this % raise or this % raise, which is always going to be lower than the non-unionized stores.
Yeah. And how did you handle like skepticism between your own coworkers, or do you think everyone was on the same page?
I think initially everyone was kind of on the same page. I think a lot of people just had trust in the people who were kind of organizing.
Okay.
And so it wasn't too difficult at first. However, whenever situations kind of changed and there was a lot of pressure from management and working conditions were changing and we were getting new hires and whatnot, they specifically would only allow people from like certain stores to pick up shifts at our store. And transferring was different. There was partners who would want to transfer into our store, but they would get either talked out of it by upper management, or something would happen where they would get in a disciplinary situation that prevented them from being able to transfer to our store. We're excited about the union. And so whenever you have all these new hires coming in and all they see is management hates these people, like really they're not doing something right, like just do your job, you know. It's very difficult to explain to people like it's more than just like what it seems. I don't know how to describe it, but it's for a greater cause. Like we're just trying to get a contract. Like that's all that this is. And once we get a contract, like that's awesome. Like,
smooth sailing from there, hopefully. And do you have any like memorable like turning points or any like memories that you'd like to share?
I think so. I was very nervous to go on my first strike and to organize my first strike.
The nerves.
Especially because, I mean, I'm very hard-headed and I love, you know, generating a broader message, but just also knowing how much management like already did not like me and that I'm about to do this was very nerve-wracking. But once we had our first strike and we had other union members from other unions that were participating in the strike and seeing, you know, how they were, you know, going about it and the different chants we would have, it was honestly very like empowering being able to like yell and
get it out.
And like, they won't come to the bargaining table with us. Like, don't get your coffee today.
Shut
like, go
it
to
down.
Dunkin'. You know, exactly. That was very fun for me.
Oh yeah,
to be able to kind of like get that, because I can't walk up to my manager and be like,
"F you, dude."
Yeah. So
that's awesome.
Yeah,
I think you're super cool.
Oh, thanks.
Yeah, and then I know you're also like, you just got into law school.
Yes.
Congratulations.
Thank you.
So very exciting stuff. I'm someone who wants to go to law school right now. Like that's kind of the plan. Like you did
Yay.
political science, I'm doing public policy. I love my major. Like I know some people sometimes drop out or they're really unhappy with it. Not me. I think I picked the perfect one for myself. But I'm so interested to pick your brain about what is that process like? That is super overwhelming. I'm approaching the time when I need to be studying for the LSAT. So
Gotcha. Yeah.
do you have any tips, tricks?
I think I do a little bit. For me, I don't have lawyers in my family.
Okay.
So this was like a uncharted territory. I have a sister, like she has her master's, so I knew like she had gotten to that point. My one of my mom, she also has her master's, but that was kind of about it for
Education
beyond
levels, yeah.
undergrad. And I kind of, thankfully, I had a lot of support. One of my friends is already in law school. We went to undergrad together. We were roommates freshman year. She was able to provide me with a lot of insight about the process.
Yeah.
I would just say in general, like, plan on preparing for the LSAT, you know, months before you take it. It's not something with the way that the LSAT is it's an exam and you study for it, but it's more so like you're teaching yourself kind of how to think differently and how to take the test. Almost not that it's like a game. There are logic, or not anymore. There were logic games on it, but there's kind of like a way in which you have to study that teaches you how to take the test versus like taking it to retain.
It's not
like,
a
the
memory-based
content
test
of the test.
Gotcha.
Yeah, no.
Yeah. Well, I want to ask Sandy, how is taking the test all the way, you know, back when for the LSAT? Do you think there's any big differences between then and now?
Yeah, it's been far too many decades, so the test is structured very differently from the way that it used to be structured. It still has the same goal of trying to predict how will this particular candidate do once they get to law school.
Right.
It is reasonably predictive for the first year, but not much beyond that.
Right.
And then it has a number of competitors now.
What do you mean by that?
That there are other exams that are out there. When I was applying to law schools way back in the 20th century, everybody, you had to take the LSAT, and that was there was no way to get in without taking the LSAT. A number of the schools now say, well, if you take the GRE, we'll accept that in lieu of the LSAT.
Oh, I didn't know that.
Yeah, and then there are some other schools that are working along on other exams, and there's a new form of exam out there now. I'm not fully versed in it at all, but they keep moving along. And then there's a whole issue of what are you really testing on the LSAT, and how do you look at things like the so-called logic games section, because you're looking at abstract logic and abstract reasoning, which is very difficult to relate to the law. And by the time you're done with law school, you mostly realize, there's not really logic or reason to much of what goes on.
Yeah.
There is in some sense, but there's plenty of stuff that you're just like, really? That's the way the law is? And it's like, yeah, that's the way the law is.
And maybe this is a dumb question, but is the LSAT like something that is this test that's approved by the state, or is it something that's approved by more on like a national level? Because if there's the acceptance of new tests.
Yeah, whether to require the exam is a decision of mostly up to the individual law schools.
Okay.
Although the ABA has sort of the ABA has this quasi-regulatory role, some would say a very regulatory role, in approving law schools. And for a long time, they were like, well, part of what we have is you need to require entering candidates to take the LSAT, just like they used to require libraries of a certain minimum size and volume of books, a certain faculty to student ratio, and relatively reasonable compensation to the faculty members. All sorts of things that kind of reached out there. And the so that was the way it was just for a long time.
Yeah, I imagine.
The exam to me was just kind of like a glorified SAT exam. In fact, that's it's like the LSAT. It's like the law school admissions test. Correspondingly, or you had the MCAT, the medical college admissions test.
Yeah.
But it was more logic. It was more, I don't know, more reading and trying to extract things. One of the things that happens when you go to law school, as you pointed out about adjusting your thinking, is that you get into law school and there's a lot of emphasis on, think like a lawyer, which is everything is in writing, but nothing is really written because the words as they are expressed on the page are susceptible to an extraordinary universe of potential interpretation.
Yeah.
And a lot of, at least to me, the early part of law school is the eye-opening part about you think that's what the language means, but it could mean this, couldn't it? And it could mean that, and it could mean this other thing. So surely we would want to have then some tools to derive what did the legislature mean when it used these particular words. And so what are those tools, and why are those tools effective, and how did we develop those tools, and which people still debate forever, even in constitutional law.
Right.
The issue of how do you interpret the Constitution, what's the appropriate analytical framework for addressing questions that arise, and that is more like a boiling pot on the stove than people like to think. I think that when people outside the profession want to get a lawyer, they just want a yes or no answer. Like, can I do this? Can I not do this? Can I do this? Can I not do this? The single greatest mark of somebody has successfully gone through law school is that the potential client shows up and says, here's my problem, yada, yada, yada. Can I do this, or am I prohibited? And the response is, it depends.
Is that what it means to think like a lawyer? There is no yes or no's. There's just a way to analyze the situation.
Yes. It's a way to analyze the situation. Clearly, there are some instances where there are clear yeses and clear no's. But there's a lot where it's, a lot of gray area. It's like, yeah, you could read what you're doing, and you could read the regulation, or you could read the statute as being a violation, or there's another way of reading the regulation or the statute, and it's not a violation.
Right.
And so you can't give your client a get out of jail free card. you can't say, I'm your lawyer and I say you can do it, and this is the shield that will protect you forever. It does not.
Yeah.
But it helps to guide clients. And some things, the answers are, they're in the gray area. If you do it in a very loud and obnoxious way and make certain that it comes to the attention of the regulators, and you frame it in a way that looks shady, then the regulators are probably going to pay attention to it and find that it is shady.
Yeah.
But if you come in and you do it and you show that there is no ill intent, there's no deceit here, that this is a legitimate way of doing something within the spirit of the regulation, then the regulator may just be like, nothing to see here, and move on.
Right.
And so that's how you get into these sort of it depends answers. So
Frustrating, but it's good. Yeah. And you mentioned first year of law school.
right.
Do you have any advice for Madeline going into her first year of law school? Just maybe somewhat what to expect, or something of that nature?
I'm not certain that
It's the same.
it's the same in any way. I
Yeah.
often think about it's been so long since I was in law school. It would be like me taking my experience in law school and comparing that to what was law school like in the 1940s.
Right.
It's just that spread. There's all sorts of things that are available now that in terms of resources of the law that were
Yeah.
not there before, in terms of the online databases, in terms of the ability to reach out and obtain analysis of all sorts of legal issues, even the most minute legal issues. Somebody somewhere has probably put out an article or a post, and you can turn that up and learn really the most recent knowledge on a number of issues pretty quickly. So that's
Very helpful.
very, very different, very helpful. And you can get exposed to actual writings, briefs, opinions, recordings of oral arguments, all of these things that were, when I was there, you didn't do it. I mean,
Yeah.
when I went to law school, like today, if the Fifth Circuit hands down an opinion, then that opinion is available online the day it comes out. So I can get that immediately. If I'm counsel in that case, I actually get an email from the court saying, your case is decided, and here it is.
Yeah.
In the days of yore, you got it in the mail because there was no other way of doing it. And now every day I get an email's got a summary of Fifth Circuit opinions. In the old days, even when I was working in the federal courts, opinions came out, and the reason they were called slip opinions is because they were printed like little pamphlets as opinions. Every opinion was a separate pamphlet, and you would get a package, and it would have a stack of these pamphlets. and when I was at the district courts, like that would show up in the mail, and you would open it up like, oh, this is what the Fifth Circuit is up to.
Yeah.
So it was nothing like the online stuff that you have now.
Lawyers have to be very adaptive.
Yeah,
It's
and
constantly changing.
constantly changing. I had a case just within the last week where one part of the case, in the related part that's pending in Nebraska, there was an appeal of a preliminary injunction, and it was argued before the Eighth Circuit in oral argument. And I was able the next day to pull up the oral argument, listen to the entire oral argument,
Yeah.
identify what they think the issues are, get a sense of where the Eighth Circuit might be going.
Yeah.
And none of that resource, none of that nuance was available back at the time. So,
Yeah.
and even hyperlinks now, if you pull up a case in most of the major legal databases, law is always very self-referential. You see, if you go to law school and you read like the early decisions of, even the earliest decisions of the U.S. Supreme Court, they're like, oh, well, we're doing it this way because there was some case in England that did it this way.
Right.
Or because this is how Blackstone in his commentaries on the common law in England tells us how to do these things. So a lot of law, when you read it, it tries to cloak itself by saying this all should be very clear from just looking at the cases that have been decided before. And one of the things to realize in law school, no, it's not at all clear at times from cases that have been decided before what the outcome of this particular case is supposed to be. So in terms of going back and looking at, in a given opinion, where they would say, the precedent in Jones's case and in Zavala's case and in Smith's case, that's how we get to this result. So you would read that and you would think, okay, I ought to go read those cases to see what they really say, which you always should, because from time to time, when this court says that's what that court said, it's not necessarily what that court said. So there's a lot to be gained at times by going back and reading what they're actually relying on.
Yeah.
When I was in law school in the early days of my career, that was hard copy books. So it's like you were in the library and you had a case name and you had a citation, and you were like, okay, I need to go pull that volume and walk across the library, find that volume, and go to that page, because a case citation was like X versus Y, and then you had a reporter, generally in those days out of the National Reporter System put out by West Publishing. So you would then have an identifier for what the National Reporter was, like Texas is a Southwestern Reporter. Originally Southwestern, then Southwest Second, now we're on Southwest Third. Basically, when they hit 1,000 volumes, they start over again. They assign a new number. So all arbitrary, because you don't really have to do it that way. And so you'd have the volume, the reporter, and you'd have the page. And so you knew where to go look if you wanted to go read that case, that volume and that page. And if you had a law clerk or a judge that was very precise, then you would have what's called the pinpoint site, and we still use this. In other words, I go pull volume 781, and I open it up to page 525, and I find the opinion of the Waco Court of Appeals. But that opinion is 10 pages long, and I want to find the page that they're relying on with that discussion without really having to read the entire case, because it may discuss a whole bunch of other stuff that's got nothing to do with this point. So in a traditional site, you would then put the page where you were citing the portion of the discussion that you were relying on in the later opinion, and that was called pinpoint citing. So all of that made you get up and move around the library and pull the books out. And
So libraries used to be full of people just studying and stuff.
Yes. Libraries, the great law libraries at law firms have disappeared by and large.
It's all in here.
Yeah, it's just remarkable at your fingertips. So it helped lawyers. They actually got some physical exercise. Get up, walk, lift books, open books, put them back. So you got some exercise. And it allowed you to build your own little defilade of research, because you would have this book, and then you get another one, another one, another one, another one. And these books that would just stack up in front of you as you were researching. And you needed to do it that way, because you could go Xerox the case, but it wasn't like you could just highlight, cut, and paste and add it to your notes.
Yeah.
So you could make a copy or do something else. So you could dictate as you were, literally dictate as you were flipping through the books to get your quotes right and to get your page citations right. And so it was just entirely different. And and then you would work in firms where I'm building my defilade of cases here, and it's 8 o'clock at night. And on the opposite side of the table, you're building your own stack of cases until we finally both get sick of it and ask each other, what are you doing? And then you go out and you get a drink, and then you come back and work till 2 a.m. to get the freaking brief finished. But that's the way it was. And now it's just a click. Now it's like, I don't have to leave my chair. I just have to click on the hyperlink. Oh, and there's the case. And it goes right there. And not only does it go right there, but with the advent of artificial intelligence and a lot of large language models that are now, I think, coming to dominate legal research, you can have those 2 sentences or that paragraph, and you've got a little marker over on the right side that's like, hey, you want to see some other cases like this that discuss exactly this point? And you're like, oh, sure, I'll push the button. And off you go into the rabbit hole. And the systems have become extraordinarily good. They really have gotten better and better about turning up related cases and turning up related cases that traditional methods of research would have been unlikely to surface.
Really?
Yeah, and the
That's
reason
innovative,
the reason for that is when we talk about the law, as I call it, being self-referential all the time, if a court, say, it's 1920, and you put out an opinion, and it's very nice and it very discreetly addresses this topic, and your local practitioners in the 1920 look at it and go, oh, that's great, it addresses that topic. If that opinion is not cited by anybody, no matter how well it addressed the topic or anything else, if nobody would go out and in subsequent briefs, or particularly subsequent court opinions, cite that, then it would eventually be covered by the sands of time,
Yeah.
because nobody would ever go pull it from the book
Yeah.
because no other case had cited it.
Yeah.
And then you would, so you would lose, I think, some excellent writing that went on and some excellent
Yeah.
analysis that went on. You do not have that bias when you get into the, there's a form of it, but you don't have that exact same bias when you have sort of this neutral language model looking at text,
Yeah.
because it's just like, hey, that text is what I'm looking for, so I'll surface that one.
Right. Yeah.
And so it's a whole different way of researching the law and looking at the law.
Yeah.
It also puts a burden on the lawyer, because you got to go read the stupid cases, because do not trust artificial intelligence or ChatGPT
Yep.
to actually give you true case sites. They often do, but sometimes they fill in and they make up a site. To them, it's like
Yeah.
composing a sentence, and they see all of these millions of sentences that have apparently this
Yeah.
this weird names with a V in it, and then this sort of number, reporter, number, year, and some kind of court thing. And the language model, it's like, well, I need to have something like that in predicting what should be the next word or the next phrase in the text that I'm creating. And it looks like the next logical thing is one of these structures, so I'll just stick one of those structures in.
Yeah.
And
That's the flaw
how,
with AI.
Yeah. So when
That's
you,
a very good disclaimer to put
Yes.
out. Yeah.
you need to be careful,
Yeah.
but it's just part of lawyering. I mean, you have to be able to read cases. You have to be able to correctly cite cases to the court.
Yeah.
And hopefully you can actually cite cases to the court, and they will stand for the proposition that you want them to stand for.
Yeah.
Now, part of the art of lawyering is that there isn't always a case that says exactly what you want it to say. And sometimes there's just too many cases that say what you don't want them to say. So you need to find a way to advocate for your client, stitching together what you can out of the cases. And that brings up, to go full circle back to the first year of law school, the other thing they teach you in law school is, just because it's true for Bert and Ernie in their convertible in Florida doesn't necessarily mean that it is correct for Ted in his Volkswagen in Oregon. Fact differences, sometimes subtle fact differences, can make a difference in outcome, and being able to identify facts that can make a difference and facts that should make a difference, and then through lawyer skills persuade the court that they really do make a difference, is part of the art of lawyering that they do still teach, and that really hasn't changed all that much from back in the day when I was in law school. So that's a long-winded answer.
No, it's good though.
But it's an excellent
It's
answer.
good, yeah.
Yeah. And then just to close off, what are you looking forward to in law school?
Oh goodness. I mean, I've always liked school, so I'm genuinely excited to be back in like a learning environment, especially
Yeah.
surrounded by other people who have the same kind of interest of wanting to become an attorney.
Yeah.
I think one of my favorite aspects of the law that like Sandy talked about too is it's not like a yes or no,
Yeah.
you know, for a lot of situations. And that was very appealing to me, because it allows you, you know, given, you know, different, like you said, facts with your client situation, you're able to take those things and try your best to formulate the best argument you can. And it's not like you have to have this, this, and this.
Yeah.
For the most part, depending on what it is.
It takes a certain
there's-
type of person.
There's a certain, not flexibility, but, you know, I would like to be able to, you know, learn the law the best that I can, so whenever I do become an attorney, I'm able to guide people through that process, just because it's so foreign.
Yeah.
There's so many people, and I know my experience with the attorneys through Starbucks that represent the union. Like, I learned so much through them from, you know, kind of like, I guess, the client side.
Yeah.
Versus, you know, becoming an attorney, I'm going to be able to really talk about what this means, why I'm kind of recommending this versus this, and
Yeah, I mean, and I know you have a good heart. I know this is something you're already interested in. You want to help people, and I think you're gonna be an amazing attorney. I'm sure of it.
you.
So I just want to thank you again for coming on to the Legal Trifecta.
Thank
you know, being
y'all.
one of our first guests, you were amazing. So, yeah, thank you so much.
no, thank y'all.
Do you want to?
It was great.
Thank you. Yeah.
Yeah, and your last point really hits on an important thing, which is that law really is just a tool. That when the client comes in the door, the client wants to get from A to B, whether it's getting compensated for an injury, whether it's defeating an unfair claim against them, whether it's buying a refinery, selling a factory, exporting their goods, importing their goods, figuring out how to fly an airplane, how to raise money.
Yeah.
They come in with a whole universe of the day-to-day issues of life. And they're not there to sit in your office and talk about the majesty of the law and how glorious it is. They're there. Law is a tool. You're the craftsman. Figure out how to make that tool of the law work for me and get me to where I want to be.
Right. Yeah. And thank you so much for the listeners for tuning in for this episode, and we will see you next month. Make sure you subscribe to our podcast either on Spotify or Apple. And remember, this is a video podcast. To check us out on YouTube, The Legal Trifecta. Thank you.